Thank you, everybody. I'm sorry that my video is not working. It's always happening like that. When you need the camera to work, it doesn't work. Anyway, so on behalf of the Philadelphia County Medical Society, I would like to welcome all of the participants to this important and needed webinar. It will be very useful not only to our young colleagues that are beginning their career, but also to many of us that could take advantage of this knowledge. This is one of the many ways that the Philadelphia County Medical Society can provide benefits to its members. Organized medicine is essential to provide assistance in many ways to their members. And I hope that in the future we can talk more about this. We were very concerned that our 17,000 physicians that are in the area of Pennsylvania, of the east area of Pennsylvania, they need some support from us. And without any more delay, I would like to introduce Daniel Shea, who is an attorney with regulation. He worked with Alice Gosfield and Associate PC, and his practice is in relation to the health law and healthcare regulation, focusing primarily on physicians' representation, especially with respect to fraud and abuse compliance, Medicare Part B, physician reimbursements, and physicians' employment issues. He regularly advises clients on issues surrounding HIPAA compliance, electronic health records license agreements, physician advertising, and physicians' use of social media, as well as enrollment in Medicare. Those fields are so very important these days, and without any more delay, I'm sure that you're going to enjoy and benefit of this webinar. Welcome, Mr. Shea.
Thank you very much. Good evening, everybody. I will get these slides up here for you in just a second, if you'll bear with us. There we go. Okay, so my name is Daniel Shea. I have, oh, sorry, this is, there we go. I have some contact information here for you. This slide deck, by the way, will also be available for you. You can ask Eileen for a copy of this, or if you'd like to reach out to me directly, I'm happy to provide you a copy of the slide deck. So let's start by talking about the physician mindset regarding contracts. These are things that many of my clients have actually said to me over the years. Many physicians look at contracts as an unnecessary formality. They think that it would be a lot easier if you could just shake hands. And you know, everybody's pretty much on the same page with this anyway, right? What do we need to bring the lawyers into this for? I get questions sometimes about, can you write me an ironclad contract or make the contract unbreakable? The answer to that, of course, is no. If the other side wants to breach the agreement, they're going to breach the agreement. And then the real question becomes, who has the will to enforce the agreement and who has the means to enforce it? And we'll get into more of that as the presentation goes along. Oh, one other quick thing. For those of you who have questions in the course of the presentation, I'm going to be answering most questions towards the end, but please feel free to type them into the chat. And then to the extent that they don't get covered in the course of the presentation, we'll address them at the end. One of the other things I hear a lot is, these are all boilerplate provisions anyway, right? This doesn't actually mean anything. I don't have to pay attention to it, do I? You don't exactly, but it helps to understand what the so-called boilerplate provisions stand for and why they are significant. One of the things that especially physicians who are just coming out of training, getting their first employment agreements, worry about is, they think I should just sign this thing. I don't, want to pay money to an attorney to have my contract reviewed. And I'm worried anyway, if I ask for changes in the agreement, that it's going to blow the deal or poison the relationship. That's almost never the case. Certainly, it makes sense to ask questions about ambiguities in the agreement. I have never had a client ask so many questions that the other side said, all right, that's it, deal's off, we're done. I've had clients come close, but they were really pestering the other side and dragging things out, which I am happy to do at your request if you ask me to. Although I may advise you, I think we should make a decision now if it seems like the other side is getting antsy. The last one, and this also is very true when you are coming out of training, is I don't have any real power in this situation. They're not going to give me a sweetheart deal and I need a job. So why shouldn't I just sign this thing? I have personal experience with this. My wife is a physician. When she got her residency contract, it was, granted a 2-page document, but she didn't let me read it. She just signed it. I have never let her live that fact down. And I remind her regularly that she gets free legal advice at home. So why not take advantage of it? And all of the other employment negotiations she has used me for. So for what that's worth. Anyway, I disagree with this view that you have no power, so you shouldn't bother worrying about what's in the contract. You still need to know what's in there so that you can understand what constitutes a breach and how to avoid it, for one thing. But we'll talk about the other things that are worth knowing in an agreement as we go along. A better way to look at a contract, the main purpose of a contract is to set forth in writing what is the mutual agreement of the parties, or as we say in legal parlance, to establish a meeting of the minds. And really all that stands for is that both sides of the transaction see things the same way. They agree on all the particulars of the deal. It's important to read your contract and to understand it so you know what exactly you're getting yourself into. You may not have the ability to negotiate, but you can still know what it is that you're signing. For a contract to be valid, it has to set forth what is known as adequate consideration. That is legalese for they got to give you something to get something from you in return. That means, in the most basic sense, they have to pay you for the fruits of your labor. But also sometimes when changes are made to an agreement, they may have to give you something extra beyond just, and lucky you, you get to keep working for us at the same rate. We'll talk about that a little bit more when we get further along. When I am reviewing a contract, and especially when I draft contracts, I try to find a balance point between, with respect to duties and obligations, I try to find a balance point between detail versus flexibility. And what I refer to this as is the drop-dead theory of contracting, which I promise is nowhere as dire as it sounds. The drop-dead theory of contracting means that a well-drafted contract is one where all of the parties who negotiated the original deal could keel over dead tomorrow. New parties could step into their shoes, pick up the document, read it, and come to the same conclusions. That's a well-drafted agreement. That's one that doesn't have a lot of ambiguities, that isn't confusing, that doesn't leave people saying, well, wait, what did they mean when they wrote it this way? And again, that's a question of just how detailed something is, as opposed to how open-ended the language is and how flexible it is. It's important to understand what's in your contract so you'll know when there has been a breach, either by you or by the other party. So in addition to knowing what your rights are and what your obligations are, it's important to know what the other side is obligated to do as well, and what you can reasonably expect of them. Finally, what is one of the more important things for people who are just starting out in their careers, how do you get out of the agreement and what happens when you do? We live in an era where most physicians who will come out of training will take a job and it will not be the job that you retire from. In some limited circumstances, yeah, it may be. But, life happens. You get married, your spouse gets transferred to some other part of the state or all the way across the country. And so, yeah, you're going to pick up and move. You're not just going to stay in the same job. You might just get tired and you decide, I don't want to do this, or I don't want to practice medicine exactly this way anymore. So I'm going to change what I do, or I'm going to change the setting in which I work. So knowing how you can get out of the agreement and what happens when you do is essential when those are the kinds of considerations that are going to be a real, a practical impact on your life. Okay, so let's talk a little bit about what we're going to be discussing today. We're going to get into general contracting concerns and contract language. We're going to talk about physician employment agreement issues. This is going to include some discussion of newer compensation models and some records related concerns, auditing, indemnification, and repayment language. We'll touch on all of this stuff as we go along. In the interest of time, I may speed through some of this depending on how quickly we're moving here. Okay, so first set of contract terms are term and termination. We are effectively beginning at the end of the contract. As I've mentioned, getting out of the agreement is just as important as getting into it. So the first thing to pay attention to are the dates of the agreement. When does the agreement start and when does it end? That may not always be crystal clear. Just this week, I read an agreement where, well, I'll put it this way, contracts can have multiple dates on which they begin. There is the execution date, which is the date when all of the parties have signed the agreement. There is the commencement date or a start date, which may be at some point after that. For example, if you're joining a hospital system, when you start up, you can't, it's not like you sign the agreement and you walk in the door and start working for them literally the next day out on the floor. They need to get you credentialed. You need to get medical staff privileges. All of that takes time. So to the extent that that all needs to be done, they will maybe set a start date, which is later than the effective date of the agreement. And sometimes the effective date of the agreement is different from the signature date of the agreement, the execution date. So paying attention to the dates is really important. It's important because it can impact things like automatic renewal. And that raises one way in which contracts operate. Most of the time, I see agreements that contain within them what's called automatic renewal. You may sometimes hear this referred to as an evergreen contract. And what it'll basically say is something like, this agreement will automatically renew unless either party gives notice to the other within 90 days of the end of the then current term of their desire to terminate the agreement, or 60 days or 30 days, however long it is. Basically, all that means is we're going to keep rolling on these same terms unless one of the two parties says, I don't want to do this anymore, or you want to force a renegotiation and you say, I'm willing to do this, but I want to talk new terms. Other contracts will have a fixed termination date. So for example, it may read, this contract will run for a period of 2 years, at the end of which the agreement will terminate on, December 31st, 2026 or whatever, depending on when the agreement starts. There are pros and cons to each approach. If an agreement has automatic renewal, that can be helpful because you don't have to worry about renewing it. It'll just keep going. On the other hand, you lose a bit of leverage if they don't especially want to keep you around, or if you blow the timeline within which you're required to give notice that you want to leave. You may want to renegotiate the terms and you may not have as much leverage to do that. When a contract has a fixed term, if they want to keep you around, you have a lot of leverage because they want to keep you. And you say, well, if you want to keep me around so badly, let's see what's in it for me. On the other hand, if they don't especially care to keep you around, you lose a bit of job security that way. Termination of the agreement can also occur what's described as without cause. What that means is the agreement terminates for no reason whatsoever. Or rather, I should say, the grounds on which termination occurs do not need to be specified. They may have a real reason why they want to terminate, or you may have a real reason why you want to terminate. But it's not necessarily because either party breached the agreement or did something else that would cause the agreement to terminate on its own. Without cause termination gives you, again, flexibility, but at the cost of security. Usually these provisions are mutual, so both parties can terminate the agreement without cause, provided they give the other side sufficient notice. In some cases, I've seen agreements where the doctor has to give, well, the worst I've ever seen was something like, I think it was 18 months notice. That was a really weird situation, though. That was a physician going into a very specialized field in a very rural area. So there were concerns about how easy it would be to recruit a replacement. And the system that they were joining said, we're not changing these terms. It was hard enough to find you. If we've got to find a replacement for you, we want to know we have enough time to do it. Most of the time I see something around anywhere from 60 to 90 days, sometimes a little less than that, but usually 60 to 90. When you see this, you really need to pay attention to the length of notice that's required. As I mentioned, the upper end of that I've seen is anywhere from 6 months to 18 months in that really weird scenario. That's only happened once. But think about what that means for you in a practical sense. That means if you think, I don't know that I want to keep doing this, you have to decide to tell them 6 months in advance before you're going to leave. That's a lot of planning to do. But that's without cause termination. You don't have to give them a reason why you want out. By the same token, they don't have to give you a reason why they want to terminate the agreement. So, like I said, you lose a little job security. Termination can also occur for breach. In some cases, you will have the opportunity to cure the breach. For example, if they say something like you're required to complete all your documentation within, let's say, 48 hours of a patient encounter, and you've been getting your notes signed 56 hours after the fact, or in some cases worse than that, which I'm sure none of you would ever actually do. But some doctors I know do take a bit to complete their notes. But anyway, let's say they had some requirement like that and you kept blowing the deadline. They could say to you, all right, look, you need to get these notes done. You need all of the old notes done, and we're going to monitor you. And you need to be doing better for a period of a month. We are giving you 30 days notice. If you don't fix this within that time, this contract is done. That's an example of having an opportunity to cure the breach. In other cases, the agreement will terminate immediately upon notice. For example, if you lose your license to practice, that's pretty much the ballgame. They're going to terminate the agreement immediately. Ideally, they will do that upon notice. There's another version of immediate termination, which is what's known as automatic termination, and that can often happen without notice. What that means is that as soon as the triggering event occurs, the contract is automatically terminated. I try and get this kind of language removed from agreements when I find it, because practically speaking, it can be a nightmare. And I'll give you an example of why it could be a nightmare. One of the common grounds for automatic termination is, for example, if you lose Medicare billing privileges, or you lose billing privileges with any of the employer's third-party payers that you're required to participate with. So you get kicked out of one of those systems. The problem is, when it comes to Medicare, at least, I can't speak to private payers, but with Medicare, that termination of your billing privileges can actually happen retroactively. And what I mean by this is, let's say Medicare conducts an audit of your services, and they say, you've been doing all of this very, very poorly. We think you may have even engaged in fraud. We are reaching back through time, and we are saying you are terminated as of the date on which we first began investigating this. And that may be 2 months prior, or however long it is, or on the first date that you began your fraudulent activities. And God only knows how far back that could be. When they terminate your Medicare privileges, if the agreement has automatic termination, then technically speaking, all of the money that you got as salary after that point in time, you were not entitled to it, and you would have to repay it. And that is a nightmare. So like I say, I try and get that removed, but it's still something that creeps into contracts sometimes. So be aware of it. One of the other things to be aware of is your post-termination obligations. Also, the other side's post-termination obligations. These are typically hidden throughout the body of the agreement. They're not just going to be spelled out in the section on termination. Some obligations may be in the termination section, but a lot of them will not be. The kinds of provisions that will survive often, which are spread around, things like access to records following termination. You'll want to have access to your records in case you need to defend yourself in a lawsuit, like in a malpractice suit, or if you get audited by a third-party payer. Restrictive covenants are a classic example of something that survives termination. By definition, a restrictive covenant has to survive termination. Actually, that's not always the case. Once in a blue moon, I will see a restrictive covenant, a non-compete, for example, that only applies while you're working for the employer, and then for whatever reason, they decided this is not going to apply once the agreement's over. That I have very rarely seen it, but it has come up. Confidentiality obligations are another one that survives. Non-solicitation, which really gets lumped in under restrictive covenants. But we'll talk more about those later. Don't worry. I know that's always a very popular topic when giving this presentation. Some common grounds for termination for cause. For cause is a little bit different than breach. Breach is where you have an obligation to perform some duty or to perform a duty in a particular way, and you fail to do that. That is a breach of the terms of the agreement. For cause can be considered a breach, but usually it's for very specific things like loss of licensure, loss of your DEA certification, failure to obtain board certification or to maintain board certification. If you become what is known as a sanctioned person under the meaning of the Social Security Act. I'm assuming none of you know what that means. That's a good thing. Basically, it means that you have been kicked out of all federal healthcare programs because you've done a bad thing, or you did enough bad things that they said, forget it, you are persona non grata. For cause, as I mentioned, can also include breach. We've talked about cure periods already, so I won't go into that. I will point out that in some cases, breaches may be cured based on a time limit, so you have to do it within X number of days, or it might be you have to exercise reasonable diligence in curing the breach, and there is no time specified. That's a lot less common. Another grounds for termination is criminal conduct. Usually these are crimes of what are called moral turpitude, which is, I think, just a fun thing to say. But what that basically means are any crimes that are crimes that involve things like fraud or embezzlement or blackmail or things of that nature. Obviously, certain felonies will also be crimes that would be grounds to terminate you. Impaired physicians, that's another one. If you have an addiction problem, they may want to terminate you, particularly if it's such that it could endanger the health of the patients. So let's turn to duties and discuss those a little bit. One of the things that you should pay attention to is your call schedule. What's it going to look like? This isn't always spelled out in agreements, by the way. It doesn't always say, you're going to take one night every 3 weeks, or you're going to do a 1-4 call schedule or something like that. It may just say you will share call equally with other similarly situated physicians. That should raise the question of, okay, how many of those are there? How many other similarly situated physicians are there? Am I the most junior member of the team and all the rest of the partners are going to be off playing golf or enjoying their evenings out to dinner with their spouses while I am taking call and having a miserable time of it? Or am I in a multi-specialty group and I'm the only member in the group who is of this one particular specialty? You're part of an orthopedic group, but you're a hand surgeon, whereas everybody else is, hips and knees. That could impact what your call schedule looks like. So pay attention to that. Sometimes an agreement will spell out your schedule. It's extremely rare that they go into much detail. Most of the time what I see is just a general statement that you'll be a full-time employee. In some cases, I will see something that says you're expected to work a minimum of, let's say, 40 hours per week, 30 hours if you're doing a job that offers maybe a little more work-life balance. Sometimes more if you're working a much tougher job. They may also break that down and say that you're expected to spend, 30 hours a week doing clinical work and 10 hours a week doing administrative work. Or, if you take a teaching position, for example, they may split your clinical time and your teaching time. Things of that nature. I think it's worth finding out how they go about scheduling, just as a matter of due diligence. How far in advance do they schedule? How many other docs are in your same specialty? If you need coverage, how does that get handled? Do other physicians in the practice take coverage? Is there that one guy that's always off on vacation for some reason, and you're not entirely sure why that is, but for whatever reason, Phil's always off in Greece for some purpose. I don't know. Find out in advance how that actually works. That's not something that's going to be spelled out in the agreement, but it's worth finding out for purposes of, your day-to-day life. When it comes to your duties, what does the agreement say about extracurricular activities? That can include moonlighting, where, for example, you're working for a physician group, but you want to pick up a couple of hours at your hospital because, you want to fly first class to Hawaii that year for vacation, and that's how you're going to pay for it. Can you do volunteer work if that's something that you want to do? Some doctors want to engage in charitable work, or maybe they've already been doing it and they want to be able to continue that. Find out if you can do that, under your agreement. What's it say about things like speeches or writing articles or conducting research, giving expert witness testimony? One of the other things that you may want to pay attention to is whether you get to keep the proceeds from these activities. Some employers will say things like, yeah, you can do whatever you want as long as, number one, you get your own insurance for doing it when you're not working for us. And number two, that it doesn't impact your time when you're working for us. So as long as you're meeting your obligations, we don't care what you do on your own time, just carry insurance for it. Oh, and you can keep all the money. Other employers will say, you can only do what we say you can do. Oh, and by the way, we keep all the proceeds, but we'll consider it for purposes of your bonus calculation or anything in between. So worth finding out about that stuff. Representations and warranties are another major clause in contracts. They are very important. They act as an inducement to the other party to enter into the agreement. And what that means is these are preconditions for the agreement. And if any of these turned out to not be true, the other party would have said, forget it, we don't want you. That means if in the course of you already working for them, it turns out that they were not true or they cease to be true, they can be punishable by, in addition to whatever contractual damages the other side can prove, also punitive damages. So when you see representations and warranties, or as lawyers refer to them, reps and warranties, pay very close attention. Make sure that you can comply with them. The typical provisions that I see are that you are licensed in whatever states you're going to be practicing, that you have current DEA or other state-controlled substance certifications, assuming that's relevant to your practice, that you have or will obtain board certification within X amount of time, and that you will maintain it once you have obtained it in the first place. That you are not currently and never have been a sanctioned person and are not otherwise excluded from federal healthcare programs. It's rare that I see this next one, but it has come up occasionally, that you've never been a whistleblower, that you've never declared bankruptcy, that you are not currently under investigation for any wrongdoing. One that I see that I always kind of roll my eyes at is physician represents and warrant that physician will comply with the law. Well, how are you guys supposed to know whether you're going to comply with the law? You'll do your best, but you're not lawyers. You went to med school. Law school was the fallback position. I know this, or at least that was the point that my cardiologist grandfather always made. Much to his chagrin, he had 2 children and several grandchildren who all became lawyers, but he bore it in good stride. Anyway, compliance with law, I try and get that removed or at least modified. one of the ways that I do that is by including language that says, to the best of physicians' belief or knowledge. Another example of this is like with things like investigation. To the best of your knowledge, you're not under investigation, but there are literally investigations that are sometimes secret, where the subjects of investigations don't know they're being investigated. I spent a summer working at the U.S. Attorney's Office when I was in, actually when I was in college. And I worked on one of those secret investigations. I can't tell you any details about it. I will take them to the grave. But what I can tell you is that that is a reality. There could be investigations for physician fraud where the target of the investigation has no idea that they're being investigated at the time and will not find out until much later. So, you know, to the best of your knowledge, you're not under investigation. One of the other things I also try and adjust is the timing of some of this stuff, particularly for those of you who will be coming out of training. If you move to another jurisdiction, you will not be licensed to practice there. You will need to get a license. You will need to probably get Medicare billing credentials, or at least even if you had them during residency, which you probably do, have those updated so that you are now tied in with the practice that you're joining. When the agreement is written as if you have that stuff already, I try and get it changed to say that you will have by XYZ date those credentials, and that acknowledges that you don't have them yet. Otherwise, you're making a representation and warranty to which you actually can't stand good for. You know, you don't have a license, you'll get a license. Compensation. Let's take a very brief discussion of this. The old model, the one that everybody knows and likes, is you get your salary and you get your bonus. Your bonus could be productivity based, it could be profit sharing. Maybe it's just something that's at the whim of your employer where they say, well, we had a really good year, so here's $3,000 extra dollars, enjoy. That old model is rapidly fading, and it is giving way to a new model, which is often that you will have some lower base salary, and then a portion of your salary or a portion of your compensation will be what's known as at risk, where you have to hit certain productivity targets. So for example, a work RVU target. You may not know what any of these terms mean. I do not assume knowledge, but basically this means you have to be productive up to a certain level. Now, a lot of times when you're just starting out, what you'll see is, let's say, a 3-year agreement where for your first 2 years or for your first year, you're operating on the old model. You get a flat salary. If you're eligible for a bonus, you get a bonus, the end. That's usually done because you don't have an established book of business. You don't have regular referral sources. You're just getting started. We don't know how productive you're going to be. So it's not fair to say you got to hit the ground running and meet XYZ target every year. But after a certain point, they're going to say, okay, you've had your warm-up period. Now it's time for you to start producing. And so what they may say is you were getting 500,000 a year, and I'm just throwing out a number here, a nice big fat round number. Or let's lower that to something maybe a little more realistic. You were getting $200,000 a year. Well, now we're going to drop that down to 160, and the other 40,000 is at risk. You'll get it if you hit your target. If you go over your target, we're even going to pay you bonuses that are based on the productivity, where you're going to get XYZ amount of dollars for however many work RVUs you go over that target amount. They may also say, forget the productivity, we're tying all of this to quality metrics or to patient satisfaction reports, things like that. But basically the new model, and the one that I think is going to be a lot more common, is you're given a little bit of a grace period when you start, and then after a year or two, you're expected to be more productive, and more of your salary is based on productivity. In some cases, all of your compensation may be based on productivity, and that can work in a couple of different ways. I can explain some of that towards the end if people have questions, but that's just to give you a sense of how compensation tends to work in agreements as I see them these days. One of the other things that frequently sneaks in I put this in all of the contracts that I draft where we represent the employer. Voluntary repayment clauses. Under Medicare, employers, physician practices, really any healthcare practitioner, is required to engage in voluntary repayments of money that they receive when they discover that there has been fraud. Not even fraud, but overpayments that they have received. If they fail to return that money, then it becomes treated as if it were fraud. It converts to what's known as a false claim. So you build, and I'm just giving a rough example here, you build level 5 E&M visits, and it turns out that your documentation wasn't good enough to support that. So in the course of an audit, it's discovered these probably should have been level 3s, just based on the amount and nature of the documentation. Maybe you've experienced some of this in your training. I don't know. Sadly, you will experience it when you're out working. There will be coding experts who will tell you how you have to code your services, how you have to do your documentation so that you get paid. It is an unfortunate byproduct of what I think is the somewhat broken aspects of the American healthcare system, but it ain't going away anytime soon, so be prepared. But let's say your employer conducts an internal audit on past billing. They discover, wait, it looks like we can't support these claims based on the documentation. What they then have to do is give that money back. If they hang on to it for too long, it converts to false claims, as I said. And in addition to the amount of money that they would have to give back, they will also have to give up to 3 times that amount as additional payments, as penalties. So employers are very careful about this. And one of the things that they want to make sure of is that if the problem was that you screwed up in your documentations or in your performance of services, that they are not on the hook for all of that money. So what they will say is, if you are the cause, we can demand that you return money to us. It is frustrating to see that if you are the employee, but the best advice that I would offer is do your best with coding, pay attention to the guidance that your employers give you, and if you need to fight about it down the road, try and make sure that these provisions are written in a way that gives you the ability to challenge their auditing decisions. Maybe even bring in your own expert to prove that, no, you didn't do anything wrong. But like I say, we can discuss that more a little later. Malpractice insurance. This is also one of these provisions that by definition kind of has to survive termination of the agreement. State law requires physicians to carry malpractice insurance. All states require this. Ideally, your employer is going to provide this for you. It would make the most sense for them to do that because they are the proverbial deep pockets. If a patient gets injured, they may come after you in your individual capacity. They will absolutely be going after your employer in their corporate capacity. There are a couple of types of insurance here. One of them is what's referred to as claims made, where you're covered if a claim is made during the period. So while you are paying policy premiums, a patient says, I've been injured, and they file a lawsuit. That is a claims made claim. It's a claim that is occurring while you are paying for coverage. Occurrence-based coverage means that you are covered for anything that occurred while the payments were being made, even if that is after the time that you have made the payment. So with claims made coverage, it's only while you are covered under the policy. When your employment terminates and you're no longer covered under that policy, claims made coverage by itself will not protect you if a patient comes back, let's say a year after the fact, and says, I've only just discovered that I was injured by your incompetence, so I'm filing a lawsuit against you. That's a real concern for physicians. Typically, the window for malpractice claims is 2 years from the date on which it's reasonable that the patient would have discovered the injury. And sometimes injuries may occur that aren't discovered until well after the actual date of the injury itself. So claims made would cover you only while you're covered under the policy. Occurrence means doesn't matter if you're still with us or if you've moved on, you're covered. Extended reporting is what you get when you had claims made coverage. I mention all of this so that if you're looking at an employment agreement and you see that they offer claims made coverage, you pay attention to who's covering tail insurance. Tail insurance means you're covered for acts that occurred in the past. That will usually be paid by your previous employer. In some cases, employers will say, we will not provide tail coverage. You have to buy that yourself. That's not ideal. You don't want to have to do that. It's just more money that you have to spend. In some cases, I have seen, for example, a 3-year employment contract where if you terminated within the first year, you pick up the tail coverage 100%. If you terminate in the second year, it's split 50-50. The costs are split 50-50 with the employer. If you terminate in the third year or thereafter, the employer picks up 100% of it. So that can play out different ways. Prior acts coverage is like tail coverage, but it basically just means that a new employer that you join says, oh, geez, we realize you were not covered by your former employer on a tail coverage basis. So we're going to buy that coverage for you. That's prior acts coverage. As I mentioned, the employer usually provides this. Pay attention to what kind of coverage they provide, because the claims made coverage necessarily implicates tail insurance. And that, of course, raises a question of what happens after termination. You're going to need tail coverage, probably. The real question is just who's going to pay for it. And I've already given you the example of how that can vary, with an employer who may make an employee pay for it. Okay, everybody's favorite section, restrictive covenants. I'm going to start by saying restrictive covenants are not binding in every state in the union. California, for example, is very anti-restrictive covenant as a matter of public policy. Pennsylvania, on the other hand, allows restrictive covenants. And when I say restrictive covenants, I'm talking about a couple of different things, actually. These can include anti-solicitation clauses, by which I mean you're not allowed to go and poach business sources, poach patients, go to former employees and say, hey, I'm leaving, you should come with me. Obviously, anti-competition or non-competes are the other big one that will say things like you're not allowed to engage in the practice of medicine or engage in the specialty in which you're employed for a period of anywhere from 1 to 3 years following termination within, and usually they have to specify some geographic scope. For restrictive covenants in the states that allow them, for them to be enforceable, they have to be limited. They can't just say, you're prohibited from the practice of medicine here on planet Earth forever. That's a ridiculous extreme that wouldn't be enforceable. Typically, the way that restrictive covenants work is that they are limited in geographic scope, and they are usually limited to a reasonable range from which the employer draws its own business. So that can vary depending upon the setting. In a city like Philadelphia, a 1-mile restrictive covenant is pretty reasonable. A 10-mile restrictive covenant, unless it's for like a real specialty unit or a specialty practice that brings in people from 10 miles away, that's pretty unlikely. There are enough hospitals and physician practices in this area that, people who live in Bucks County are going somewhere in Bucks County. People who, live in Montgomery County are probably going to Mainline Health or, somewhere out there. So the scope of it will depend. On the other hand, if you're out in the Lehigh Valley, something like a 25-mile radius, that's reasonable. They're actually pulling people in from 25 miles away because of the nature of the environment and their patient base. Again, these kinds of clauses have to be limited in duration. Usually what I'll see is 1 to 2 years. Occasionally it'll go as high as 3. They're often limited in the types of services. So they can't say, you're not allowed to do any kind of work for anybody who is a competitor of ours. It'll usually be something like, You're not allowed to work as a physician or as a corporate officer or a medical director for one of our competing businesses. And they also have to give you adequate consideration. In most cases, when you're signing the agreement, the adequate consideration is the job. On the other hand, when you are already working for an employer and they realize one day, oh my God, we never had people sign restrictive covenants, let's circulate an amendment to the agreement, they have to give you more than just you get to keep working here at the same salary. They got to give you something of value. Maybe it's an extra day's vacation, maybe it's a $2,000 bump in your salary, but they got to give you something for it. Restrictive covenants will typically include liquidated damages provisions. These exist as a way for the employer to guesstimate what their damages would be. It's really hard to calculate what their actual damages would be. So just to make things quicker and easier, we are estimating liquidated damages of, and a lot of times what I'll see is something like, 2 times your salary, 1 times your annual salary, something along those lines. Or it may be a fixed amount of, $80,000, $100,000, however much it is. It's also got the dual impact of scaring the heck out of you when you read that section and making you say, boy, I really don't want to breach this provision. They can also often obtain injunctive relief, which basically just means they can get a court order, an injunction that will prohibit you from working within the restricted area. A lot of times these clauses will also say that these will kick in regardless of the grounds for termination. I try and get that changed. I don't think restrictive covenants should apply if you have to terminate because the employer has breached the agreement. Like, let's say they just stopped paying you all of a sudden. Didn't give you a reason. Wasn't even because there's a global pandemic, which really did happen to some of my clients. They took pay cuts during the worst of the pandemic. But let's say they just, they're lousy at running their business and they fail to pay you for a month or two. And you say, okay, I need to make a living, so I'm out of here. You've breached the agreement. I don't think the restrictive covenant should bar you from getting a job somewhere else when they breached. Likewise, if they say, this is great, but it's just not working out, so I'm sorry, we're going to have to let you go, and they terminate without cause, I don't think that you should be bound by the restrictive covenant. A lot of times employers won't agree to that, but I think it's worth a shot to ask for it. The types of things that'll be prohibited, as I mentioned, also can include competitive investments, meaning forget working for somebody else. You're not even allowed to invest in another company. One final point on this, excuse me for a second while I take a sip of water here. One final thing to bear in mind is the impact of consolidation. This is a big trend in healthcare today. Lots of mergers, lots of physician practices getting gobbled up by big systems opening up, new outlets or buying old hospitals in broader areas than they used to operate. And what that can mean is you got to pay real close attention to the geographic scope clause. If they say something like you're not allowed to practice within 10 miles of the employer, well, what if your employer is the Penn Health System? They're out in Lancaster now. How far do you got to go to get a job? So I try and get that restricted to something like anywhere that you spent more than, 60% of your clinical time in the course of a year. Or, if it's satellite locations that you spent more than 10% of your time working, something like that. So not just anywhere that an employer happens to plant stakes, but somewhere where you actually worked. That would be reasonable. Something to keep in mind. Okay, amendments. This is how contracts get changed. Typically, these are changes to an agreement that have to be in writing. They're usually written in a formal sense. A lot of them look like miniature versions of contracts. It's like a contract, only shorter. It's not a side letter. It's not an email. It's not a verbal handshake agreement, both of the parties usually have to sign. In some cases, amendments may be made unilaterally. So for example, I just read a contract 2 days ago that included a clause in it that allowed the employer to unilaterally amend the bonuses that it would offer. Base compensation was left untouched, but if they wanted to add a grounds for bonus, they could do that. If they wanted to take it away, they could do that. If they wanted to alter the terms and conditions on which you would qualify for the bonus, they could do that. That was up to them. You would have no ability to object to that under that agreement that I reviewed. In other circumstances, you might have the opportunity to object. On the other hand, the employer might say, okay, that's fine, you can object, but that'll mean that our agreement is terminated now. And then they still have to go through the process of providing you with adequate notice and terminating in accordance with the rest of the agreement. They can't just say, well, we're doing an amendment, so sign it or get out. Again, unless the rest of the agreement says that they can do that, which if I'm your lawyer, I'm going to try real hard to make sure it doesn't say. In other cases, there may be amendments that can be made, and if you object to that, they say, okay, that's fine. And life goes on, no changes. You may see the phrase incorporated by reference in an agreement. What this means is that external document that we're talking about, that's part of the agreement. So typically this will apply to things like policies, procedures, bylaws, manuals, handbooks, amendments, exhibits to the agreement. When you see XYZ is incorporated by reference herein, get a copy of whatever that is and look at it. The reason being, as I mentioned, these documents are effectively part of the agreement. If they include obligations in them, you need to know what those obligations are. If they include, policies under which the employer has to comply, you need to know what that is so you can hold an employer's feet to the fire if they fail to do that. When there are inconsistencies between these external documents or the attached or incorporated documents and the base agreement, there needs to be what's called a hierarchy of documents. One of the documents needs to say that it's the controlling document. So for example, you might sign an agreement. This won't happen with an employment agreement, but you might sign a different agreement that includes a HIPAA business associate agreement. And the business associate agreement may say something like, to the extent that there is a conflict between this business associate agreement and the base agreement, the terms of the business associate agreement will control. And really that's the language that you're looking for. The terms of XYZ document will control. Just as sort of a goofy aside, one time I was reading an electronic health records license agreement. The base agreement said that it was the controlling document, and the exhibit to the agreement said that it was in fact the controlling document. I pointed that out to opposing counsel, who thanked me for the note and promised to fix that, which they actually did, but mistakes sneak through sometimes. As I mentioned, other things that will be incorporated: employee handbooks, medical staff bylaws when relevant, compliance policies. That can be their HIPAA compliance policies. It can be fraud and abuse, maybe a social media policy that they have, conduct policies, benefit policies, and bonus calculations can also be incorporated. So if those aren't attached with the agreement, get a copy of them and review them ahead of time, ideally before you sign. And then if you've got questions about them, ask your lawyer to try and, make sense of what's in the documents. Unfortunately, it is not all sunshine and daisies in the practice of medicine. There are some times where you will end up in a dispute with your employer. There are a couple of ways that those disputes can get handled. The most obvious one is you go to court. This is almost always an option. I say almost always because sometimes you will see arbitration as an option. And if the arbitration is binding arbitration, a lot of times it will be controlled under the Federal Arbitration Act, which means you have to go through arbitration. It's not something that the court can resolve because you've already agreed to that. Arbitration is a formal process. It's not as formal as going to court. You don't often have people standing up and shouting, "Objection!" in the middle of an arbitration. hearing, although it could happen, I suppose. Arbitration, one of the reasons why employers like it is because it is private. If you go to court, that's a matter of public record. Assuming someone's willing to pay the fees to pull the document, anybody can get a copy of those documents. And in some cases, you can get it for free. Arbitration, on the other hand, is private. It's sealed. It's not public. In some circumstances, arbitration may be faster and cheaper than going to court. You can also, however, have negotiated internal mechanisms or private appeals mechanisms. So, to settle a dispute, maybe you've got to go in front of the Human Resources Commission in, that your employer sets up, or you got to go before the peer review committee to settle this or that issue, or the appeals committee, or something along those lines. And you deal with the dispute that way, and then it says if that can't be resolved, then you go to court, or then you go to arbitration, or something along those lines. Something to pay attention to is whether the agreement states that this stuff is going to occur before or after termination. For things like arbitration in court, you're probably going to end up doing it after termination. Once you're going to court, things are probably acrimonious enough that you're not going to want to keep working at that place. In some cases with arbitration, that may be the case as well. With the internal appeals mechanisms, though, that's usually pre-termination. Ideally, a lot of those things are set up to avoid the need to terminate. Boilerplate provisions. I'm going to go through this relatively quickly. Boilerplate provisions are boilerplate because they appear in every contract. They're so standard they may as well have been stamped. That's what the boilerplate language comes from. These provisions exist in every contract because if they're not there, there's a real problem. Waiver of breach means that if one party fails to act on the occasion of another party's breach, that doesn't mean that you have waived those grounds to assert that the other party has breached for all time. That clause appears in every agreement because if it doesn't appear, once one of the parties does something wrong and the other party fails to object, they have effectively waived that ground for breach. So, needless to say, this shows up in every agreement. Change of law provisions show up in almost every agreement because certainly within the realm of healthcare, the laws change, not infrequently. About 12 years ago, we had the Affordable Care Act get passed. There are changes to the Medicare rules all the time, and they can impact the way that contracts operate. Fraud and abuse laws get changed not infrequently as well. And it may turn out that the business model that has been set up becomes completely unworkable when the fraud and abuse laws change. So as a result of that, the parties need to be able to revise the agreement without necessarily terminating it. And a change of law provision lets them do that. Otherwise, you could choose to revise the agreement, but one of the parties may say, well, this contract's unenforceable now. It's impossible to execute because of this change in the laws. So bye, I'm out of here. Change of law provisions avoid that. As I mentioned, arbitration language, these will typically show up. It will also specify where this arbitration will be conducted and under what set of rules. I try to get that to be the American Health Law Association, alternative dispute resolution rules. The AHLA is an organization of, it used to just be health lawyers, but now it's a whole range of people who deal with matters of health law. It's an organization that's very experienced in dealing with this stuff. These are people who specialize in this area of law, and therefore their rules of dispute resolution also are designed around the needs of healthcare law. So I try and get that included. Where this will occur is usually wherever is convenient for the employer, and you're probably not going to have the ability to dispute that. Assignment basically means that if one party wants to say, well, I know you contracted with me to do this, but I'm going to have my buddy over here do it instead. Your employer is going to want to be able to assign the agreement, especially in this era of mergers and consolidation. Because you are engaged in the performance of personal services, you will not be able to assign the agreement. That should come as no surprise. If they recruit you and you say, well, this is great, but my cousin Steve is going to take over for me now. I mean, that's pretty ridiculous, right? So that doesn't really happen. There's no assignment made by physicians. But the employer is going to include that, and you'll want to see what the agreement says about assignment. If there's any question of like, is venture capital going to come in and buy these guys out? Okay, so some basic principles here. Do some due diligence. Do a little research about the group that you're thinking of joining or the employer that you're joining. Did they just have a great big settlement with the government? Are there stories about them treating their employees poorly? Is there, everybody that you've ever talked to says only wonderful things about them? Either could be the case, and anything in between could be the case, but it's worth finding that stuff out ahead of time. Please read the contract. If you're going to hire a lawyer, it helps if you have a sense of what's in the agreement, because you can ask your lawyer specific questions like, oh, by the way, when you're doing your review, I saw this one section that didn't make any sense to me. Can you explain what that means? Or is this a problem? Have you ever seen this before? Your lawyer will hopefully answer those questions for you. As I mentioned, get all of the ancillary documents, those things that are incorporated by reference. But even stuff that isn't incorporated by reference and is just mentioned, the policies, the procedures, the handbooks, the bylaws, get copies of those and look at it. You're going to be expected to comply with this stuff, so it's important to know what the expectations are, ideally before you sign. Realistically, that's not always going to happen, but do your best to get that information ahead of time. Get a legal review. I joke about how law school was the fallback position. But you guys didn't go to law school. You went to med school. You know how to do things I couldn't begin to figure out. But I went to law school. I do this for a living. I read contracts all the time. I'm familiar with what's common in this realm. I know what appears in contracts. I know what the phrases mean. And I'm also perfectly happy to negotiate on your behalf with the other side. You may not be comfortable with any of that stuff, and you shouldn't be expected to be. So have a lawyer help you out with this. Even if it's just, your friend from college who works in a different field. If you can't afford, a lawyer, but they're willing to give you a freebie, at least have somebody look the thing over so they can say, oh man, this provision here looks really bad. You may need to pay someone who's a specialist in this area to explain what's going on or to negotiate this. But at the very least, have a sense of what it is that you're signing and get a lawyer to help you make sense of that. When there are problems or ambiguities, recognize you can clarify or renegotiate those terms. I'll get into that a little bit more as we go on. When you sign the agreement, first, please do sign the agreement. You would think I wouldn't have to mention that. Sadly, you would be wrong. I have clients who have operated for years with an employee who never signed the agreement. They all acted like it had been signed, but for whatever reason, they just either they couldn't find the signature copy or it never existed in the first place. But please sign the document. Also, make sure all of the pages are there. 1, 2, 3, 4, 5. If it suddenly jumps to 9, find out where the missing pages are. Likewise, if you see exhibits or addenda or something like that, if it goes from exhibit A to exhibit G, find those missing letters. If they were omitted on purpose, okay, fine. Let's just include a page that says, these other exhibits were omitted on purpose, just so we don't run into any problems down the road. When you are negotiating the agreement, recognize most contracts are not written in stone. Now, when I say that, particularly when you're starting out, there are guardrails on that. For the most part, the terms of the agreement, what they're expecting of you and what they will give you for it, that's probably not going to have a lot of wiggle room in it, particularly by the time that you get the actual contract itself, as opposed to just an offer letter. But there are provisions that may read as gobbledygook in there. Sometimes this is just a function of bad editing. The old section 3 got deleted, and the new, or the new language merges the old section 2 and section 4 into one section, and now it doesn't make any sense. It's not even legalese, it's just nothing. That kind of stuff you can get fixed. If there are terms that are undefined in the agreement, but they're listed as those terms that are initial caps, like, you know, the first letter of each word is capitalized, those typically mean this is a term that means something. And you look through the agreement, if you don't see a definition for that, well, find out what the heck that term means and let's add that definition to the agreement. Ambiguities can also be clarified. Sometimes they'll change it in the agreement. Other times they'll just say, oh, here's how we actually interpret that. And that's better than nothing. Ideally, I'd like the agreement to be changed. The reason being, sometimes, you know, the old attorney who was working there, who understood how everything worked and was pretty easygoing, decides they're going to retire. And the new attorney is kind of a jerk. And so they view the agreement differently and they say, we're going to enforce this differently. Or, you know, there's a new chief executive officer at the company and they take a much harder line on things like, you know, when do they enforce restrictive covenants and when do they let it go? So I try and get ambiguities clarified. When you are trying to negotiate with them, whatever you do, try and phrase stuff in a way that the other side is going to care about. That's actually a problem for them that they want to fix, as opposed to just, well, I'd really like it if you did it because it would make me happier. They don't really care about your problems. They've got their own to worry about. I mean, to the extent that they want you to be there and be happy, yeah, okay, they care about your problems. But for the most part, if you can phrase a request for a change in the agreement in some way that the other side's going to actually care about, that matters to them directly, they're a lot more likely to agree to that change. One of the other things to bear in mind, no matter what is written down, if the other side wants to breach the agreement, they're going to breach it. But then what really counts is, what does the agreement say? Does it give you the ability to enforce against them for their misconduct? And then that is going to raise another question. Do you want to pull the trigger on disputing this issue with them and fighting with them about it? And in some cases, and I recognize that this sticks in the craw of every physician I have ever talked to, in some cases, it is cheaper, faster, easier, and better for your long-term sanity and probably your blood pressure to just walk away. Sometimes the best revenge is a life well lived, rather than extracting a pound of flesh from the other side, even if you're in the right. Sometimes, especially if you're in the right, if you're not going to get that much out of them at the end of the day, and it's going to cost you an arm and a leg and your mental well-being in the process. Using a lawyer in all of this will help. In some instances, I will negotiate on behalf of my clients, even with respect to the contract changes. I'll talk to the other side, I'll handle all of that. That can be more expensive for them because they're paying me for my time, but I'm happy to do that for them. Other times what they'll say is, you know, there aren't that many changes in the agreement, but I appreciate your insight into this stuff. I'll take it from here. That's fine. If you're comfortable with that, go right ahead. Sometimes what I'll do is I'll try and split the difference, where I'll modify whatever letter or advice I gave to the client into something that they can then turn over to the other side. And they can just hand the thing to the other side and say, I don't know, my lawyer said we should do this. Let me know what you think. It's a little more palatable for some of my clients to do it that way, because it comes across as a little less adversarial, you could say. But whatever you do, using a lawyer is going to help in this process. Please don't try to, as you might put it, self-medicate. This last slide here is just an additional resource that you can use. It is available on our website. It is free. It's an article that my boss wrote many years ago, but it still is good advice. And it's written in lay people terms, not in legalese. It's meant to be read by doctors. And it's about understanding contracts. And with that, I will open it up to questions. Give me just a second, and I will stop my screen share here.
Thank you, Dan. That was really insightful. I hope everyone enjoyed, and I cannot stress enough to all of you, just how many years we have worked with Alice Gosfield Associates, and in particular, Dan Shea, who has been just an incredible asset to the Philadelphia County Medical Society, to the resident section, to the young physicians, and to the entire medical society as well. So Dan, we cannot thank you enough. And I'm sorry I didn't get to introduce myself. Eileen Ryan here with Robert Miyamoto, staff of PCMS. I'm your program director. And I see we do have 2 questions down here, Dan.
Oh, 2 of them. Hold on just a second.
Just one.
Oh,
Just one? Okay.
So I see a question here that says, if you are moving to a new state for employment, do I recommend identifying a contract lawyer in the state of employment, the state of your current residence, or does it matter? For the most part, it probably does not matter. I will say that I review contracts for employment that is based in other states, not infrequently. As long as you understand, I'm admitted to practice in Pennsylvania. I'm not admitted to practice anywhere else, so I can't give you legal advice in the sense of here's what the law says in another state. I can tell you stuff like California doesn't honor restrictive covenants. That's pretty low-level stuff. But when it comes to references to state law or concerns about that, I will defer to local counsel. One of the ways that I sometimes handle that is, I'm happy to do a basic contract review for a client. But if we hit weird state law, I'll call up, a colleague that I may have in that state and say, hey, I've got this contract and it says X, Y, and Z. You ever seen anything like that? How's this really work out? And usually we can get sort of a curbside consult, if you will, from our colleagues, and they do the same with us. If you're really concerned about it, if you think that or if you know for a fact that the agreement makes a number of references to state laws that you have to comply with, or that will affect the agreement, or I don't know, like you're joining a public health group where, or like a government entity that does engages in public health in another state, and it's all bound by the state Medicaid regulations or things of that nature, then yeah, you should go with a local attorney.
Dan has graciously agreed that I will be sending all of you the deck that you just saw, all the information that Dan provided tonight. I think it will work, Robert. If anyone wants to unmute themselves and ask a question, please feel free at this time.
Sure. I also see another question in the chat.
Right ahead.
Yeah, we have another question here. Generally speaking, how do contract lawyers charge for your services per hour, per page of contract, general lump sum? Most of the time, it's going to be on an hourly basis. In some instances, some lawyers do a lump sum. For me, I actually do a discounted rate for people just coming out of training during their first year of employment after training. So normally my time is billed at, well, let's see, we actually just changed our rates relatively recently, and I made a note for myself because I'm always forgetting this. I believe it's $3.75 an hour, and what I do is a discounted rate of $300 an hour for people just coming out of training. Most lawyers bill by increments of tenths of an hour, so every 6 minutes basically. And if it's a quarter of an hour, they'll bill you for a 0.25. But essentially, that's how contract reviews will work. As I mentioned, in some cases, some attorneys will say, "Yeah, I'll do it for a flat, $500 fee." What I typically do is I can guesstimate roughly how much it's going to cost. I usually don't take more than 2 to 3 hours to do what I call the initial review, which is to review a contract, write up a letter, send it to my client, and then my client and I have either an interaction over the phone or an email exchange to discuss next steps. After that point, it's anybody's guess, because if you want to take over the negotiating from that point, great, knock yourself out. You want me to do it? Well, I can't estimate how much it's going to cost. A lot of that's going to depend on how much back and forth there is, how much you want to push on an issue, how much the other side is willing to give. You know, some attorneys that I work with are an absolute walk in the park. And, you know, half of them I've done multiple rounds with them of requesting the exact same changes over and over and over in the same agreement. And so it's sort of, you know, it's just like the old tap dance routine with them. And it goes very smoothly and very quickly. In other cases, I may not know opposing counsel, or they might be kind of a jerk. I don't know if you knew this. Some lawyers are jerks. It's a real, you know, it's a shame, but it's a professional reality. And sometimes you run into that even in contract negotiations. So, you know, it's difficult to estimate past that point, but that's just a general overview. I have never heard of an attorney charging per page. That would be really odd. It may end up kind of working out that way. I mean, longer contracts obviously take longer to review. But I will also point out that the page limit is not the only thing to pay to keep in mind. Sometimes you can have line spacing issues. Sometimes you have font issues. I have read agreements that are, well, it's only 5 pages. Well, yeah, but it's 3 columns of 8-point font. So that actually amounts to closer to, like, I don't know, 30 pages, double spaced 12-point font. Which is part of the reason why, you know, if someone's like, oh, it's only an X page contract. Well, I can't tell you how long that's going to take. Not exactly. And some contracts are worse to review than others. Some are, you know, worded in a very clear, straightforward way. Others have a ton of errors in them, or I have to keep pointing out a lot of problems or ambiguities or something like that. And so the review can take longer. So that's how it breaks down. Does anyone else have any other questions? I will also say, if you don't feel comfortable asking a question here, you have my contact information in the slide deck. Please feel free to shoot me an email there, or give me a call at the office, and I'm happy to speak and, you know, just provide general information separate from actually getting you signed up as a client. And what I'm talking about is the kind of questions like what I'm answering here. Not, well, my contract says this, what do you think? If you want that kind of information, I got to get you set up as a client.
Was that another question that just came in, Robert?
Oh,
Yes.
advice for finding a reputable contract lawyer in general. Well, there's a couple of options. You can sometimes talk to the other side and say, hey, is there anybody that you guys have worked with on the, you know, as opposing counsel a lot that you would recommend I contact? You know, depending on the nature of the employer, maybe you trust their advice, maybe you don't. You can go with word of mouth. Ask colleagues in the practice that you're joining who they used. You can ask friends of yours in the area. You know, if you have friends who live in the area, hey, who'd you use? I've gotten a lot of business from referrals from people who wound up working for the same practice where a previous client worked for. So I guess folks are saying, oh, I use Dan, you can use him. Okay, great.
You got the best resource right here.
This, I have to say, we usually get at least 1 or 2 clients out of this speech every time.
Yes, there's no doubt about it. All the vetting, all the information, certainly your Philadelphia County Medical Society does all that homework for you. And we're very, very lucky that Dan does a program similar to this, and other ones. At least twice a year, we do the contract review program, if not more. And we also ask all of you for suggestions. If there's anything else you would like to hear Dan speak on, we're more than welcome to do that for all of you. So just please shoot us an email. We'd be very, very happy to. Is there any other further questions?
I don't have a question.
Any other final? Hello.
I just would like to thank you so much. That was a wonderful presentation. Thank you.
Happy to
Thank
help.
you so much for being here. And most of all, we want to wish all of you a very, very happy holidays to everyone. Health and happiness, of course, in the new year. Any final words, Dan and Robert?
My advice, I just want to reiterate, read your contract, have a lawyer help, don't self-medicate.
And is our president still here? Dr. Morgenstern, would you like to have final words if you were still here?
He's not still here.
Yeah, I think he signed off.
You think he signed up? Okay. Are there any other further questions? If not, we will adjourn for this evening till we see you next time. And again, you'll be hearing from me. And Robert, thank you as always. Dan, thank you so much for all of your time that you give us.
My pleasure. Happy to do it.
Good night, everyone.
Right.
Good night, all.